My Lords, I had two things to think about over the short adjournment. The first was the taxing question: who is a member of the Church of England?
We were puzzling about that ourselves.
Well, we've been puzzling ourselves, and the answer is, for these purposes at least, it's purely the person who makes the relevant declaration. So under the church representation rules, they say one of these three declarations, the prior considerations are, of course, you have to be baptised over 16 and so on. What you do is declare you are a member, and that in itself is constitutive of being a member for these purposes. The other question was the point raised by my Lord Sales in relation to Article 9, and unsurprisingly, I think, my Lord, that you're almost certainly right, that although the cases always find that the religious organisation is not a public authority, and then it's a second limb of the argument, and there is also no internal dissent because of religious autonomy and harmony, if one were to lose the first half, and if, in fact, the religious organisation were to be a public authority, it is perhaps difficult then to see how one would set up exemptions from the normal ways that rights apply vis-à-vis those public authorities. That may be a further argument why I would suggest we're right on public authority, because it really does show quite how far any different conclusion would drive through all of the Strasbourg cases, which do have this second principle in for which I contend, this no internal dissent principle. That plainly is a feature of the cases. But, as I say, those cases always say no public authority as finding one.
So it may well be that the no internal dissent principle, in effect, is subordinate to the first principle.
It's subordinate because as soon as the state arises with all of its powers, of course, then naturally it's difficult to read down the rights of any individual vis-à-vis the state, I suppose. And difficult to view the state then as the way in which the individual expresses their rights equally.
Yeah, thank you.
And of course difficult for the religious organisation to represent the individual pursuant to Latter-day Saints. I mean, it all flows together essentially, the position of the authorities in relation to all of these different points. So that's Article 9. Article 8, ambit, for the Reverend Yvonne Clark. Now, you have my submissions already, that I say her own Article 8 rights, directly engaged or for ambit purposes, are irrelevant, because she's not relying on a combination of 8 and 14 so far as she is concerned. She's exercising a solely representative function. So point number 1 is that I say this is irrelevant. Point number 2, if I'm wrong on that, we need to go to the Royal Cayman Islands police judgment, which is at page 3033. I'm sorry, 3018 is the first page of that judgment. And as my Lord Hodge said earlier, the headnote explains is concerned the mandatory retirement age of police officers, and for a group appointed up to a certain date, the age was 55, the group thereafter it was 60, and that was said to be discriminatory on the Cayman Islands equivalent of ambit Article 8 with age discrimination Article 14. If we go to page 3031, we see issue 1 by letter G. Did the mandatory retirement of the individual police officers on the ground of age fall within the ambit of section 9? That's the equivalent of Article 8. In paragraph 56, we see a reference to the domestic cases and the Secretary of State for Work and Pensions, and Lord Bingham saying the further away a situation is from the core values of the right, it's intended to protect the weak of the connection and exercise of judgment, but a tenuous link is not enough. Paragraph 59 on 3033, there has to be a value judgment as to the proximity between the facts at issue to the core values which are engaged in respect of an employment-related dispute between the individual and the state. The link must be more than tenuous. Then in paragraph 66, which is on page 3036, we see Denisov and Ukraine being addressed. which of course concerned a judge dismissed from his position as president of the Kyiv Administrative Court of Appeal, with, he said, corresponding damage to his career, reputation, social and professional relationships. And in paragraph 67 on that same page, the last sentence, it notes a reasons-based approach and a consequences-based approach, which are the two ways in which ordinarily a private life issue under Article 8 might arise in this sort of context. And we see that again in paragraph 70 over the page in 3037. So in my learned friend's case, the reasons-based approach is not referred to, so Reverend Yvonne Clark wasn't dispossessed or won't be dispossessed due to something in her private life. So those are the cases where someone might be dismissed for their sexuality or something like that. We see that in paragraph 71. Instead, it's a consequences-based approach. So we see paragraph 72, and it's italicised in this judgment, the bottom of page 3037. This will only apply where the consequences are very serious and affect his or her private life to a very significant degree. In 81...
Sorry, where was that again?
That's 72, which is...
The very bottom of the page, 337.
Yes. Thank you.
It's the italicised words, my lord.
Yes, thank you.
So when the argument isn't that you were sacked for your sexual orientation, for example, but the argument is the consequence of losing a job would be so terrible for your private life, that's a particularly high bar that one has to meet. And one sees in paragraph 81, which is on page 3039, we see again consequences-based approach. They have to be very serious, at the top of page 3040 now, affecting private life to a very significant degree. And of course, in Denisov, the loss of that prestigious judicial position did not meet that threshold. And here 80 and 81, of course, in the context of this case, it's for ambit purposes that these principles are being distilled because it's a discrimination claim. So ambit 8 to be applied with the equivalent of 14. If we go back to the facts of the Cayman case in paragraph 94, that's at page 3043, we see in that case the application of the consequences-based approach. So you have to consider the severity of the consequence for the individual police officer. And the board considered in that case that the consequences of retirement were insufficiently serious, not least because retired officers could be rehired, although they had to start at police constable and work their way up again. And in paragraph 99, the judgment, this is the last reference, considers ambit separately and holds that the lack of any very serious consequences which would affect the officers' private lives to a very significant degree means that there's only a tenuous link to Article 8, so it's outside ambit. So I say even if the Reverend Yvonne Clark's Article 8 rights were relevant at all to the appeal as brought, on the grounds as they are brought, which it isn't, we're plainly not in a world where we meet those very high threshold tests imposed by the case law. It's not enough to say I'd lose my social standing in my relationships and so on. It has to be something more than that, and something unusual. So I'll turn then, if I may, away from ambit into sub-issue 4 of issue 5. Does the scheme have a disproportionate effect on UK ME persons? So my learned friend and I essentially agree, I think, on the legal approach. It's the well-known legal approach set out in the Crown and SC, which of course is the leading authority now, set out in paragraph 53 of the judgment in that decision. So step 1, this is at page 2677 in the bundles. It has to be shown...
Please give us a second to get there. 2677.
2677.
Yes. Thank you. Thank you.
So just to set context, of course, your Lordships will be very familiar with that case, but there's been an overview from paragraph 44 onwards by Lord Reid of the correct Strasbourg approach to an indirect discrimination claim in Article 14A, combined with Article 8 in this case. And we see at the top of page 2676, his Lordship works through direct discrimination, Philimonos discrimination, and then in 49 we get to DH in the Czech Republic, indirect discrimination. And that's what your Lordships are considering today. Over the page 2677, again, his Lordship considers DH, then 52 SAS, and then in 53, his Lordship summarises the correct approach to this sort of case. So it has to be shown by the claimant, this is the first sentence of 53, that a neutrally formulated measure affects a disproportionate number of members of a group of persons sharing a characteristic which is alleged to be the ground of discrimination, so as to give rise to a presumption of indirect discrimination. That's step one. Once a prima facie case of indirect discrimination has been established, the burden shifts to the state to show that the indirect difference in treatment is not discriminatory. The state can discharge that burden by establishing that the difference in the impact of the measure in question is a result of objective factors unrelated to any discrimination on the ground alleged, and that requires the state to demonstrate that the measure in question has an objective and reasonable justification, in other words, that it pursues a legitimate aim by proportionate means. And we see in brackets the judgment in Biao, to which my learned friend took you this morning. So we're agreed as to the basic approach to be taken to the questions here. And I also refer in my case to Delve, which I don't need to take you to, but of course that establishes there needs to be the correct causal link between the measure and the disproportionate effect. So Delve was a case, perhaps that, I will take you to it. I haven't said that I won't take you to it. I will take you to it quickly. It's at 2377. And we see in the headnote a challenge to the legislation raising the state pension age for women from 60 to 65, equalising it with men, and then raising it again for both. We see at the bottom of the headnote that, amongst other things, this was said to be indirectly discriminatory under Article 14 combined with Article 8. And then the indirect discrimination part of the judgment starts at paragraph 17.
Which page do you have?
That's on page 2401, my lord. And their lordships consider Baroness Hale's judgment in Aesop, in particular statistical relevant evidence in that case in relation to BME candidates and older candidates. They performed less well in the relevant exams, and no one knew why, and so on. And then in paragraph 72, over the page 2402, the relevant comparator group in this case was identified as men between the ages of 60 to 66. In paragraph 77, which is the bottom of 2403, the appellants say that because a higher proportion of women in their age group need the state pension to pay for their basic living costs, they suffer a particularly prejudicial impact in relation to the pension age. And then in paragraph 79, we see on page 2404, their lordships correctly view that as a significant expansion of the law.
This is paragraph
79, my lord, on page 2404. In paragraph 81, in particular, their lordships say that the divisional court was focusing on the lack of a causal link between the disadvantage in the measure So it's not enough that persons with a protected characteristic, on that case, are more in need of the pension because the pension impacts on everyone in the same way, and there's the insufficient causal link between the neutral measure itself and the alleged detriment. And we see they describe the nature of the causal link, then in paragraph 82 they don't accept that that causal link is sufficient to establish indirect discrimination in that case. Sorry, my lord. Oh,
I didn't know. No,
sorry. So we rely on Dell for the proposition, of course, one has to identify who we say has been affected, who we're comparing them to, look at the way the measure affects them, and then work out the causal analysis of how I'm saying measure unhelpfully in a case in which measure is the word for the statute, but the way in which the scheme, in this case, affects them differently, how it's said to affect them differently. Before I get into the evidence, I'd like to say a very quick thing about or in response to my learned friend's submissions this morning, where a few times he said that we've fallen short evidentially and we've failed to adduce evidence of one type or another. So I should say that I rely on the entirety of the documents appended to the petition and to the answer in accordance with the regime set out in the measure for one of these appeals. And those include contemporaneous documents. I rely on them. So I rely on the representations that were made to us. We sent them to the bishop. I rely on the bishop's response to those representations. I rely on the notes of the oral hearing contained in the full statement of reasons. You'll have seen the full statement of reasons in which we describe what happened in the oral hearing and then give our reasons at the end of it. And we have also adduced some limited witness evidence. I'm going to take you to some of that witness evidence. But if the complaint being made against me is that I should have addressed all matters by way of witness evidence, I say that's plainly incorrect. I can rely on contemporaneous documents in the normal way. In this procedure as well, we also have the answer, and you'll have seen the answer, which we treated as a document in relation to which duty of candour applied, consistent with the authorities. So that is a lengthy document in which we set out our understanding of the factual position. We rely on that. And we also, in this case, have an unusually detailed SFI containing a host of agreed facts, and I rely on that as well. So I want to make it quite clear that we have an ample set of pieces of evidence for your lordships to consider.
And sorry, which was the disclosure document that you're referring to, or where's the bundle reference for that?
For the answer,
yeah.
That is in my bundle 3, at page 907.
Thank you.
And that runs to 941. And previous decisions of previous boards make it clear that that's a document which we should approach candidly, and we did.
Most of it's in the SFIs.
Most of it was agreed,
Yes.
Ultimately. Yeah, the SFI bears
The SFI is very
similarity.
detailed.
It's very detailed. It's very similar to the answer. If I could start with the church approach to ethnicity of leadership and ethnicity in congregations, and I start with that, or in parishes, I start with that as a distinct point because it's important when we're considering stage 1 in the analysis, so this is disparate impact, it's important to recognise that in this context is something with a theological or doctrinal or missional overlay to it. So when we're considering what is a specific mission, what is a good mission to the relevant group, the UK, ME, worshippers and residents in the parish, assuming for present purposes that they are properly represented by someone in this hearing, and you already have my submissions that they're not. But when we're asking ourselves that question, we have to think about church mission and church approach in general to these issues. So if I could ask you to turn up the witness statement of Bishop Rosemary Mallet, which is at page 95 of the bundle. So she's now Bishop of Croydon, so relevant suffragan bishop. The diocesan bishop, of course, is the Bishop of Southwark. I hesitate to make this point, but I don't know if you're aware or not, but Bishop Rosemary is herself a black woman and a very dominant black woman in leadership in the church, and so speaks also from that position. So page 90 is the beginning of her witness statement. At paragraphs 22 and page 95 to 26, she sets out in some detail the considerable hard work of the Diocese of Southwark, in particular in relation to equality and diversity, which is obviously an extremely important issue. So that's by way of background, and we see throughout the documents evidence on this. Then we get to paragraph 27 on page 96, and this is important, that the diocese does not have a policy of appointing UKME leaders to UKME majority congregations or parishes, nor, obviously very importantly, of appointing white leads to white parishes. She says that would be clearly inappropriate, but it's also contrary to the duty of ministers to serve everyone in their parish. So pausing there for a moment, this is really inherent in the notion of the cure of souls, that the parish priest has responsibility for the cure of souls of everyone in that person's parish, regardless of their religion, regardless of whether they come to church or not, regardless of their ethnicity. And this is a very important doctrinal or theological approach, a religious idea. And she says that any suggestion that a parish should have a minister of a certain ethnicity would be incompatible with a parish minister's duty to the cure of souls in the whole parish. Now, I appreciate that my learned friend now says, oh, well, it's not to do with the ethnicity of the leadership, it's to do with the persons in the parish whom one is serving. But the same point still applies, that one can't be a parish priest and minister solely or exclusively or even predominantly to a subset of that parish that is inconsistent with the Church's approach to the cure of souls and the relationship between a parish priest and their parish. We see that in paragraph 28 over the page, on page 97. When appointing ministers, it's important to find suitable clergy who will minister to the needs of all, including the members of the church community, but also the people who are in the parish but not of that community. It therefore would not be appropriate to provide, and she says UKME leaders, but it could be any leader who professes to do this thing, to seek to provide for the needs of a specific ethnic-based community, whether black or whether white. The parish priest, she says, is not the ethnic-specific chaplain to an ethnic-specific congregation. So that's important. And then in 29, we of course see that one can have different outreaches or different engagements, of course, with different groups, Spanish language groups and so on, but that's a different thing. So that means we say that members of one racial group can have no justified grievance as a matter of the mission of the church if they're ministered to by a person of a different racial group, or if their racial group is insufficiently selected out of all the different races and ethnicities that there are in the parish. That doesn't happen and they would like it to happen. That's contrary to the doctrinal religious approach.
I think Mr. Thomas will say that's not the case he's making. He'll say, I'm not saying you have to have a UKME priest. What he'll say is the Reverend Clark was conducting a particular form of ministry which the community appreciated and wished to retain.
I see that, my lord, and that's a slight nuance in his case, but that's fine. But we would say still, if the specific nature of the ministry is that it's focused solely on a particular ethnic or racial group within the parish, yes, that falls foul of the same religious principle.
Yes.
The second point I'd like to make is that when we're thinking about differential impact, we do, in my submission, need to think about the entirety of the scheme, so all the parishes who are affected, But we also need to think about what the scheme will look like when it's in effect. So we know that the parish church is not going to be closed, it's going to become a chapel of ease, and there will still be services there. We know that there'll be an additional minister appointed, but a pioneer minister, which is a different kind of minister. It's not an incumbent, but it's someone with a particular outreach vocation. So we know there'll be a there will not be the lessening of provision, which I think my learned friend would have you believe. And we see that. I'm going to take you through the documents. That's the second headline point. Turning now to the nature of the alleged differential effect. As the case has developed at different times, I've struggled to identify exactly who the group is that's said to be disadvantaged, and in comparison to whom. And there was an exchange earlier today between members of the board and my learned friend in relation to the current posed pool, which would appear to have a world where white people and black and minority ethnic people are affected in the same way by the scheme. My learned friend disavows an approach where one would look at the other parishes as well. But at different times in his case, he has looked at the statistics in relation to the other parishes. The position of the other parishes is, of course, highly relevant in any event when one thinks about justification, because one thinks about how well can those other parishes minister to black and minority ethnic persons. But I confess that I have found it difficult to see exactly what the case is that's being articulated against us. If I just take you to some of the relevant facts so that you have the facts, my lords, then if we start with the SFI, page 947, so paragraph 11 of the SFI 947, this is a paragraph to which some of your lordships referred already. But we see the data in relation to the parishes is given here. So we start with All Saints Spring Park, population of 10,100, and that makes it the most populous of the parishes. If you flick down through the next two paragraphs, you'll see St John's 6,400 and St George Shirley 8,200. So All Saints Spring Park is the most populous.
And can I just be clear, is that taken from the electoral roll in the sense of national elections?
Yes.
Right.
Yeah. It's the census, I'm told.
Census, yes. Okay, census.
So yeah, this is the total population of the parish. And of course, the approach of the Church of England is that everyone who resides in a parish is relevantly within the parish for the cure of souls. And then we see 56.4% of the population was of white ethnicity and 43.6% of UK ME ethnicity. If we go to St John Shirley in relation to that same statistic, we have 60.5% white, 39.5% UK ME, and then St George Shirley, 58.8%, 41.2%. In my submission, these figures are all very similar. They are a little different, but they're between 43% and 39.5% BME across the three. So it's just not accurate to say that All Saints Spring Park is more diverse than the others. That's wrong. And then when we think about deprivation or poverty, a point that's been made by my learned friend is that All Saints Spring Park is a poor parish, a very poor parish, and so needs to be treated differently. But we have the figures here, the last sentence of each of these paragraphs. All Saints Spring Park was the 4,807th most deprived parish in England out of 12,000. Pausing there for a second, we don't have comparative stats for this, but in Bishop Rosemary's witness statement, the bishop notes that Spring Park is currently 146 out of 294 parishes in the diocese. I don't have that figure for the other two, so it's exactly in the middle for Southwark, and it's about just over a third of the way up, I suppose, across the country. But it's profoundly wrong to say that it is one of the most deprived parishes. On no view is it one of the most deprived parishes. It's in the middle of the diocese. Then we have the last sentence of paragraph 2. St John Shirley, 10,459th most deprived parish, so therefore comparatively affluent. And then St George Shirley, 5,073rd most deprived parish in England. So pretty much the same as All Saints Spring Park. So those are the statistics about the parishes, which are served by the churches. And then if we go to paragraph 14 in the same SFI, we see the church at All Saints Spring Park has at all material times since 2010 had the lowest attendance of the 3 churches by a considerable margin based upon the effective UCC's own returns of statistics for mission. So that's taking the evidence of the appellants at face value at its highest. Now, there is a lot of evidence in the bundles about congregation figures, attendance figures, and I could take you through them in some detail. We have evidence from various visits where there were 15 people there, 20 people there, very low figures. That's contested, and it's very difficult for your lordships to form a view on those kinds of contested facts in this kind of hearing. But those are contested, but the first sentence of paragraph 14 is us giving the most favourable view possible and the other side agreeing, lowest by a considerable margin, despite how populous it is. Turning to the racial makeup of the congregation of those who come, this is in paragraph 15. And I popped up earlier when you were looking at this paragraph, my lords, to describe it. So what I say now probably will be no surprise. But we see that at All Saints Spring Park, 11 people were there, and 7 out of the 11 were of a UKME heritage. So that is the majority. At St John Shirley, there were 75 people in the congregation, and 7 or 8 were UKME origin. And at St George Shirley, 65 people there, and 13 were UKME heritage. So what we have, and this is the submission I made earlier, is a world in which if we say what is the proportion of the congregation, we end up with a position where All Saints Spring Park have a greater proportion of their congregation being of UKME heritage. If we ask in absolute numbers how many of the 10,000 people in All Saints Spring Park come to the services, or 7 of them, how many of the 6,000 people who live in St George Shirley go to those services, 13, and then 7 for St John Shirley. So if we compare absolute numbers, All Saints Spring Park is doing rather worse than the others. If we do it by reference to proportions, it's doing considerably better. And that's the point that we make, albeit not exactly in those terms, in paragraph 17, the first sentence.
Would do worse as a proportion of the residents in the parish?
Absolutely. So we've got 10,100. We know it's about 43% UKME, 4,300 people, 7 of them are coming.
Yes, from the figures we saw this morning, I think the demographic of those attending All Saints was the white community tends to be, as an expression at my stage in life, perhaps I don't like using elderly, while the younger and more energetic tended to be UKME. That seemed to be the pattern of the figures.
Certainly on those statistics, I think. As I've said, I'm not entirely sure where they come from. They were given to the DMPC. They seem to relate to the congregation, but if one tries to add up the numbers that one can infer from the percentages used, one ends up with a bigger number than 30 in the congregation. It's quite difficult to work out exactly where they relate to. But yes, overall one does see on those statistics a bit of an age difference, I think. We also have in paragraph 16 of the SFI the fact that the commissioners heard evidence, and this is in the statement of reasons, that 40% of those attending certain services in St John Shirley were of UKME heritage, and that St George Shirley had a diverse congregation. These points are obviously very important. They're important to the legal analysis and factual analysis which your lordships have to perform, but it's also really important to St John and St George, who risk coming out of the hearing before your lordships board rather badly. And these are churches that feel very strongly that they have a diverse congregation and they do a good job of engaging with their UKME worshippers and the residents in their parishes. So I do want to emphasise that point. The next sentence in paragraph 16, on 25th of April 2023, the current Bishop of Croydon, Right Reverend Rosemary Mellett, provided over that deanery confirmation service on behalf at St George, at which half of those confirmed were of UKME heritage. Those attending for confirmation included parishioners from other parishes in the deanery, not St George, so perhaps of less relevance. But then we have figures held by the diocese indicate that on 14th of May 2023, 20 out of 54 adults present at a children's Eucharist at St John Shirley were from a UKME background. And if I pause for just a moment there and go back to the witness statement of the Bishop Rosemary, at page 101.
This is the source of the information in the SFI.
It's not always the source.
I know this particular paragraph you've just taken us.
Exactly, but also I wanted to take you to paragraphs 44 through to 46, because it was said by my learned friend that we insufficiently consider the position in St John Shirley and St George Shirley. And of course here she does talk about going to that Eucharist service. But 44, she says, I do not consider that the parish is providing effective ministry to its residents. Now, we'll unpack that a little perhaps later, but it was said by my learned friend sometimes, there's no complaint about the ministry being provided. And I'm very sorry, and it's an awkward submission to make in this public forum, but there is complaint about the ministry. There is not effective ministry in All Saints Spring Park, and we see that running through the evidence, and we see that's part of the full statement of reasons, which I'll take you to when we get to justification. That's first sentence. I also consider, says the Bishop, that effective ministry to all residents of the parish could be provided by the other parishes in Shirley, with a pioneer minister in post to focus on the residents of the parish. The parish is more than the area the Reverend Yvonne Clark and the ASSPCC say they're providing mission to. All aspects of the parish, including residents of Bethlehem Hospital, need to be served. Then we have paragraph 45, when she talks about visiting St John. Halfway down paragraph 45, these churches, she says, are growing and drawing in people from the communities living around them, including UKME residents. It's important to note that the parish and those other neighbouring parishes all have mixed ethnic communities and a mix of owner-occupied and social housing. Both the parish of St John Shirley and the parish of St George Shirley have a wider ambit in terms of their understanding of looking out for the well-being of the whole parish and the cure of souls of all parishioners. That's the point which I made earlier. It's clear, she says in paragraph 46, that the churches of St John Shirley and St George Shirley are able to reach out and include parishioners from a wide range of ethnic backgrounds, and that there are increasing numbers attending their churches. This indicates positively that people from UKME backgrounds will not be disadvantaged if this pastoral reorganisation takes place. So that's the core issue I'm making submissions on at the moment. Is there any disadvantage? And Bishop Rosemary says no, not in her view. Added to this, with the pioneer minister in post, there'll be an intentional focus on reaching out to and working with the whole of the community, including those from a range of UKME backgrounds, with the aim of helping to meet their needs by taking God's love in action out to them. So that is the witness evidence that I have in support of that point. So some particular reference has been made to the position of the Shrublands estate, which I'll take relatively quickly against that background, but we deal with that in the statement of reasons for our decision, paragraph 129, which I will hopefully be able to give you the page number for quickly.
Thirty-three.
Sorry. Paragraph 129 on page 33. So this is in the middle of our reasons, and I'm going to come back to this shortly when I work through justification. But just for shrublands in particular, this idea of particular outreach. In paragraph 129, the last sentence, the Commission, has also noted that the St John's Parish already had links with the shrublands estate, including participation in its food bank. And we also have, going back through the measure, paragraphs 56, measure through the full statement of reasons, paragraph 56 to 57. And this is on behalf of St George's. 56. She explained, Ms Bebbington explained, St George's work with the community, including supporting the food bank on the Shrublands estate, the parish magazine, which volunteers distributed 2,000 copies each month into the Spring Park area, and so on.
Yes, I just wanted to check on that. So is Mrs Bebbington in effect representing St George's here? Because she'd had a prior relationship with All Saints, I think.
She was formerly...
right, but for the purposes of this part of the evidence, so in effect, these are representations from the neighbouring parishes.
They are, absolutely. The parishes which will absorb the two parts of the former parish of All Saints Spring Park.
Yes, I see. Thank you.
She describes exactly what that mission will look like.
And can I ask, do we have a copy of the script of her speech? Because that seems to have been taken as read.
We don't have a copy of that, nor of any of the other documents that were taken as read, unfortunately.
All right.
So for today's purposes, we have the documents that were annexed to the petition and annexed to the answer, and we didn't, not through any great strategic choice, annex to the answer the various documentary representations that various persons filed for the oral hearing, including Lee Day. We don't have the Lee Day representations either, I'm afraid.
Yes, thank you.
So that's 56, then 74. So now is Miss Christine Healy, the Church Warden of St John's. That's in paragraph 63 on page 24. And then in paragraph 74 of her oral submissions.
I think we've moved on to Reverend Gale.
Oh, I'm sorry, yes, at the top of the page. So she's the incumbent in St John, and is describing the strong links with the Shrublands Food Bank. This is when the commissioners were asking questions of Ms Gale, and they asked her about black flight, so whether BME people would feel unable properly to worship in St John's, and how she saw mission on the Shrublands estate being carried forward. And she notes that demographics, racial makeup had changed a bit in the recent years, racial divide not as relevant as it once had been, but she thought the pioneer minister might take a significant part in mission on the Shrublands estate, depending on who they were appointed, and notes that St John's already has some members from Spring Park, including some confirmation candidates who come from the Shrublands estate. So again, just making good the point that these other two parishes and their incumbents are very well placed to serve the same missional intention towards the UKME residents and worshippers. And then, finally, for present purposes, Group 3, paragraph 83, these are people from the diocese.
Is Rosemary Mallett was Archdeacon at that time?
She was.
Yes.
She was, my lord, yes. And then in 86 on page 27, the bishop said that the primary concern in promoting the dress scheme was to provide the better pastoral care for all in the Spring Park parish area, including Bethlehem Hospital, Shrublands and the private suburbs. And then we see the main presence in Shrublands was the Baptist Church, and it was they who ran the food bank, says the bishop. And All Saints not listed on the website as one of their partners.
Yes, I noticed that. So the food bank was run by the Baptist Church, but the other two churches, or maybe all three, for all I knew, helped out.
Yeah, but it absolutely not a special feature of All Saints.
Yeah, I see.
And then finally, before I move, this distinctiveness of mission, if I just take you to the Bishop of Southwark's submissions at page 486. So what happened, as you know, I've told you enough times now, but we had all these written representations that came in. We sent them to the bishop. So the letter to the bishop starts at 467. On page 469, we list all of the representations against. You'll see, incidentally, at number 8, James Clark, Reverend Yvonne Clark's son, tying in with what we discussed yesterday. Then we have summary of all the representations against over the next pages. And then at page 480, we have a list of questions which the commissioners posed, that read all those representations, formulated some questions, put the questions to the bishop. So questions about background, how would they provide for the better cure of souls, further the mission of the church? How would they meet needs, traditions and characteristics of the three worshipping communities? Then over the page 482, set out the consultation process, tell us exactly what happened. Question 3, the bottom of page 483, what input did the incumbents have, and so on. And then for present purposes, turning through these questions, on page 486, comment on the conflicting views about Mrs. Clark's ministry at All Saints. This idea of a more inclusive ministry, attracting previously marginalised ethnic and minority groups. On the other hand, the fear that she's neglected established parish organisations, alienated many congregation members who've joined other churches. And please comment on the makeup. So we have the response, the Bishop of Southwark in blue underneath. So he says they're not related to the proposal to dissolve the PCC because that's related to financial and governance issues and the need to plan ahead for mission and ministry in Shirley. But we'll comment as follows. And then at the top of page 487, the Bishop says the three churches are inclusive and diverse, all in the liberal Catholic tradition. The diocese is committed to diversity and so on, regular worshippers for minority groups. Then we see reference to the familiar statistics, census results. And then regarding engagement with young people, there's no evidence of active engagement, of the loss of connection with uniformed organisations such as the Scouts, and the poor engagement with the parish and Christmas services for children and families are commented on in representations sent to you. The Young All Saints group referred to in the representations opposing the scheme appears to comprise people from outside the parish and outside the diocese based on a shared call letter. We're not aware of any organised youth work in or for the parish. Just pausing there, I think it's 20 representations which were in that identical pro forma. Mrs. Clark makes reference to her parish as LGBTI plus friendly. We're not aware of any initiatives in that direction at ASSP, but we are aware that both St John's and St George's are actively welcoming of LGBTI plus people, and St George's is a member of Inclusive Church. And then Southwark Vision, with the explicit published strategic objective to have leadership and representation that reflect diversity, and the strategic objectives relating to that. So what I've sought to do, taking quite a lot of time over it, I'm afraid, is take you through some of the documents, and there are a lot, but some of the documents that relate to quality of mission, how it is or may be said to be UKME specific, and to try to explain to your lordships and also to the appellants how it is that the view was formed by all of the church authorities who looked at this question, that the draft scheme would not be disadvantageous to worshippers and residents who are UKME. And that is the view of the church authorities, and I would respectfully invite you to come to that same conclusion. Turning to issue 5, if there is prejudicial impact is it justified? So I already took you to paragraph 53 of SC, where we saw that second stage of the test. We also know in paragraph 160 to 161 of SC, and we know in any event, that on occasion a margin of judgment may be allowed to the relevant decision maker. And that includes not only in economic and social policy matters, but also sensitive moral and ethical issues, and I would say religious issues, if we're in a world in which, obviously, we're a public authority and these obligations apply at all. And I also say, when considering justification, at the moment, there is, as is noted in Dr. Poole's statement in paragraph 23, an extremely challenging national mission environment, as she puts it. Parishes are being dissolved, and not just one parish being absorbed into two, but she gives the example of a situation in Liverpool where I think it was 30 being dissolved and forming 7, numbers to that effect. This is happening increasingly in the church, and the reality is difficult, evaluative judgments have to be made, and they're made by reference to a host of different factors, but the overall consideration is the better furtherance of the mission of the Church of England. And of course, a component of that is viability, financial viability, governance viability, and consideration of quality of mission. So if I take you through our full statement of reasons, which starts at page 16 of the bundle, and we list essentially the core things that happened in the oral hearing. We distill the core thrust of the various oral representations. And then on page 30, we have reasons for the Commissioner's decision. Consultation process, paragraphs 113 to 119 on page 30 to 31. I don't need to take your Lordships through that, but I do invite you to take into account, when you're considering proportionality, the considerable and elaborate decision-making process, gathering evidence from all interested parties and beyond, far and wide, and the different stages that went into that process, and in fact that preceded the process in this case, because before the statutory procedure started in the present case, there was an episcopal visitation in 2016, and there was also involvement of a body called the Archdeaconry MPC. So a different kind of MPC, but just in Croydon. The number of different church authorities that have considered this issue is considerable. So I would respectfully ask your Lordships to take that from those paragraphs.
Can I just get the chronology clear? So that this is an oral hearing meeting on the 7th of September 2021. So that comes after the bishop has given his answers to the questions. Is that right? So the answers to the questions are sort of material available for comment at the oral meeting. Is that
more than that even, Leonard? So we got that document back that I've just taken you to. We then sent that document to everyone who'd made written representations and to the interested parties. So everyone saw that, and we invited all of them to comment on the bishop's reasons. We received those back, and then we sent them to the bishop, and we got his reasons back again. There has been such a thorough consideration of the views of the affected parties in this case.
And all that's before one gets to the oral...
All that's before this. And in fact, the Commissioners originally formed the view that they had sufficient material to determine this on the papers, which is the conventional course. But the PCC, I think, and the Reverend said that they would prefer an oral hearing so that they could express their position orally. And so we said, fine, we'll have that hearing. But we felt we had enough on the papers already. But all of that information went into the mix. And if your Lordship in due course considers the chronology filed with some of the pleadings in this case, you'll see that we have the Bishop's second round responses. We have the supplemental representations in relation to the Bishop's first round responses. We have all of those documents in the bundles.
Yes, and the pages you're referring us to from page 16 onwards, that accompanied the letter of 28th September 2021, which is the intimation of the Commissioner's decision.
It is, yeah.
So this is the end of the process?
This is the end of the process. This is our decision. And so we send this out and we give notice of the right to appeal, but we're otherwise essentially functus at this point. We have prior rights to amend the scheme, but at this point it's out of our hands.
And just to be absolutely clear, so in effect, this the attachment to the decision letter reads like sort of notes of the meeting, and then the reasons separately for the decision. But presumably, the notes of the meeting are adding to the documentary record of all the other representations that have come in before, and presumably that's the reason notes of this meeting were taken and added to the file.
Absolutely.
Like, it's
so
not just this.
We have all of the Section 9 representations, referring to the terminology of yesterday. Then we have the Section 19 sub 3 representations, so our freestanding power to go out and get more information. And then we have, exactly as you say, my Lord, these oral submissions. This is a record of what was said at the meeting. And of course, the commissioners would also have had the speaking notes that various participants handed up. I apologise that they're not in the bundle.
So, I mean, it's when the commissioners come to give their reasons, those are based on the full body of evidence, not just what happened at the oral meeting.
Absolutely, absolutely, my Lord. The full body of evidence, everything. So I think I need to finish all my submissions by 2:45. So I'm going to take this relatively quickly, and I do place reliance obviously on the paragraph set out here, but there is underpinning material in relation to every single sentence that I could take your lordships to. And I do need to deal with PSCD, obviously, and then ground 3. So finance and governance, paragraph 121, that deals with running down of parish reserves to the point where they were nearly exhausted in order to remain solvent. This point had been reached even though the parish had had 3 reductions in its parish share between 2010 and 2015, and since then it offered a share of only £3,000 a year, representing only 4% of its ministry costs. So that's the amount that the parish contributes to the diocese to cover the costs of the parish existing, essentially. It's not paid this in 2020 or in 2021. I should say it's an agreed fact in the SFI, nor have they paid it in 22 and 23. And they further noted, the commissioners, this had been the least contribution from any parish in the diocese, although Spring Park was by no means the most deprived parish in the diocese. And if I just very quickly take you to a table which compares that position with the other 2 parishes which we're talking about today. So on page 492, we're back in the bishop's representations. And the table there just sets out, it's a compare and contrast between the different parishes. And we see the size of the sums being given by the others. Even if we start at 2016, when the scheme shifted from fairer shares to parish support fund, the parish pledge. St George Shirley, we see very similar demographic to us in terms of deprivation to All Saints Spring Park. £39,000, 32, 36, 37 and so on. And they pay every year, and then indicative costs covered around 50%, mid-40s, because obviously the diocese does support poorer parishes. St John Shirley, richer parish, 79,000, 80,000, 50,000. And we see in the right-hand column 110%, 101%, so on, of the cost covered. Spring Park, £3,000, dramatically lower than the other contributions. And then payment 2016 to 2018, £845 paid in 2019 and nothing subsequently. So at their best, that was covering 4% and then down to 1%. And one sees, if one looks back in time slightly, and this was in the period leading up to the visitation, they were £57,531 in arrears in 2015. And that's the extent to which they have to be subsidised by the diocese in that extremely challenging mission environment when there's not enough money to go around in any event. So that's paragraph 121. Paragraph 122 relates to the parish accounts. Now, I'll take this relatively shortly, but this is an important point because there is a legal obligation on a PCC to maintain proper accounts. The rules are set out. I won't take your lordships to it because I don't have time, but they're set out in the church representation rules, which is at page 1417, and also the church accounting regulations at page 1453.
Can I have those pages again?
1417
and 1453.
and 1453. That means that the PCC annually should provide their accounts to the Diocesan Board of Finance. They hardly ever have done that, very, very seldom. It means that the accounts need to be in a certain format, and they very seldom are, and it means that they have to be independently examined, and again, they very seldom are. And one can track through the facts over the years, and I could make submissions over several hours taking you through each set of accounts. But you may see, I don't know if your lordships have had cause to consider any of these, but recently they've essentially taken the form of a PowerPoint sort of presentation. So I'll take you just to one, which is the most recent, page 1100. So quite often they don't arrive at all, but sorry to speak in a discourteous way here, but quite often the accounts don't arrive. And then we see when they do this kind of PowerPoint presentation, they should be formal accounts. On page 1102, purpose of the presentation to provide the financial performance. It is the basic document which provides information and recommendation. And then we see some information about income and expenditure. I mean, it's very hard to understand what's going on from this document. It's obviously inadequate, and this is something which has been raised with them repeatedly. We see in the language, paragraph 122, of the full statement of reasons which I'm basing these submissions on, that there's been a problem with the accounts going back to 2015. And of course, we have in the most recent witness statement of Ms. Thomas, the diocesan secretary, the point that these are legal obligations. This is a governance matter, and it's impossible to work out what's happening with the money unless one has proper accounts. Paragraph 123 of our reasons. The Commissioners noted that the visitation in 2016 had been prompted by the PCC's failure to pay bills, and that the visitation and the inhibition of the Reverend of All Clerks, and inhibition is a period during which one can no longer officiate, and we say it's a standard aspect of visitation, had been prolonged by the delay in producing financial records. It considers that no convincing evidence had been provided to show that improvements in finance or governance had been made since the visitation. The PCC had been unable to provide completed copies of its accounts to the DBF as required by the Church Representation Rules since 2015, and offers to provide training and advice had not been taken up. It had also been unable to keep the church hall in a good state of repair, which had resulted in a further loss of income. So that's all entirely correct and well supported by documents in the bundles. I'll take a short amount of time on this because, of course, the written case against me is that the only less intrusive measure for this proportionality analysis would have been for the diocese to do more to help. So, assuming that still is my learned friend's case, I do need to take you through some of the things which the diocese did. So, first of all, in relation to the background to the visitation, if we go back to the bishop's representations at page 480, So the proposals, the draft schemes, is in the second. So the first paragraph, the background is the financial and governance problems at All Saints Spring Park, which extend back over the last decade and more. The financial issues in the parish came to the fore when creditors approached the diocese through the Archdeacon in relation to unpaid debts. The consequence of the financial issues has been that the PCC has not been able to engage missionally with the parish and has become unviable. These proposals come after several other interventions through which the diocese has sought to support the governance of All Saints, particularly in relation to its finances. The standing order of £250 per calendar month towards the parish support fund wasn't paid, and so on. Church gas was cut off. Attempts by the diocese to arrange meetings to discuss these issues met with no response from the parish. And eventually the problems became so severe that after consultation with the diocesan registrar, it was judged that an episcopal visitation was necessary in order to ascertain whether or not the parish was bankrupt. The incumbent initially responded by seeking legal advice, and action included a meeting facilitated at the offices of their legal advisors and attended by those various parties. The results of the visitation, that we have all the underlying documents in the bundle, but I can probably do it quickly by reference to this summary. The results of the visitation summarised in the report of February 2017. We have that report in the bundles. It doesn't show evidence of financial viability and cannot meet its current debts, only one-off gifts and so on. For the last 10 years, sustained by financial reserves have now all been expended. No realistic prospect of being able to pay its parish pledge. A serious deficiency in financial record keeping, which makes financial planning difficult, means the PCC cannot exercise proper oversight of this aspect of parochial life. Maybe one, but not the only reason why debts haven't been paid and checks are bouncing. Incumbent and parish officers have not provided evidence of realistic ways in which the financial and wider life of the parish can be turned round. Serious questions about the capacity of the parish as life now stands to develop and grow. Congregation is small and old. Discrepancies about how many people are attending in any event. Church plans in a very fragile state, the hall roof leaks badly. Repeated themes of breakdowns in relationships, especially between users, difficulties in communication, and difficulties in a particular meeting. Subsequent to the visitation, directions were given, and I think I will take your lordships to them, because they're at page 137 of the bundle. So at the end of the visitation, a series of formal directions is given that need to be signed up to. And we see how, in my submission, helpful these directions are back in 2017. So the report is given to the incumbent church wardens and treasurer, discussed with them, and distributed to members of the PCC. A supervisor is identified to work with the incumbent, meeting at least monthly to oversee and direct their work. Archdeacon or area dean to attend meetings of the PCC for up to 9 months. Officers at Trinity House work with and oversee officers from the parish to establish robust financial systems and reporting. Monthly financial reports provided to the Director of Finance of the diocese. Information about where we are with utility bills and so on to be provided. Accurate report, electrical inspection of the church hall to be carried out, nominated by the Archdeacon, with the diocesan office bearing the cost. Clear and realistic plan for payment, and so on. And we see it's signed by all concerned. No, I don't have time to go through everything that happened over the course of the past, I suppose it's now 7 or 8 years. But these are symptomatic of the things that were put in place to seek to assist with the parish and to turn it around, resolve its financial difficulties, and resolve its governance problems. And we have the final the final visitation report at page 954.
Do you say 954?
Oh, sorry, 173. It's taking you back to the SFI. A lot of this is in the SFI as well, but... So we see second paragraph down or third paragraph, number of directions have been complied with, but then between the hole punches for me halfway up, it's in the area of finance where there's least evidence of any progress, most cause for concern, still having the problems with the parish accounts, no signed statements, then parish finances, parish balanced its books by spending down the reserves, and the state of the account liabilities at that stage being 52,000 at the top of page 174 now. Rudimentary budget, but no budget for 2018. That was despite it having been asked for on various occasions. Problems with the PSF, problems with the future development proposal. It's important to stress at the bottom, no evidence of financial impropriety, but we are in this position where there are very, very significant issues with capacity and with financial viability, and no evidence is the conclusion there that the parish has capacity to address them, and that's really part of the course. We see that throughout the documents, we see it throughout the SFI. These are profound difficulties, and the diocese did everything it could to assist with them. If I go back to the full statement of reasons, I'm going to have to rattle through the rest of the paragraphs without turning up the underlying materials. But I say paragraph 124, which is at page 32, the Commissioners agreed with the Bishop's view that the parish of All Saints Spring Park was not financially viable, was not functioning adequately in terms of governance. They considered that a parish in benefice, which was not financially viable, was not able to make a meaningful contribution toward its ministry costs, was not able to provide effectively for the cure of souls or the furtherance of the Church's mission. Moreover, the Commissioners considered it was proper for the diocese to consider the effect the disproportionate support for one parish was having on the resources for mission elsewhere. And I say that reasoning is impeccable in my submission. The Commissioners then considered the development proposals, and one sees that there have been development proposals of different types on the stocks for years. All of them plagued with legal issues, all of them plagued with financial issues. And then we come to the end of finance and governance, 126, 127, and we then turn to provision of ministry and mission, because in a sense this is what it's all about. Mission is the main goal of the draft scheme. The Commissioners considered that the proposed reorganisation would further the mission of the Church, make better provision for the cure of souls in the context of the wider area of Shirley and the diocese as a whole. They considered that the proposed scheme, which would keep the parish church of All Saints in use as a chapel of ease, would make appropriate provision for missional need and to effective, sustainable parish units. And over the page in 129, they take account of the requirement in section 3, sub 2, sub C of the measure to have regard to tradition, needs, characteristics of the particular parishes, that's parishes as a whole, rather than a subset. But they note that the proposed pioneer minister, not yet fully defined, themselves has that different way of engaging in different groups, that they're not a parish priest, a pioneer minister. And we get to this point about the food bank again. 130, this is very important. The Commissioners also noted that All Saints Spring Park had not suggested that any of the alternative options for reorganisation considered by the Croydon AMPC, so that's the earliest stage in the process, before we get to DMPC, consultation meetings putting out different proposals for discussion.
There were the options of status quo and so on,
exactly.
Which I think are recorded in the SFI.
They are.
Yes.
They are. It's not said that any of the alternatives were better. There is no less intrusive alternative, save for status quo with a bit more help. And then 131, that addresses representations in the alternative direction. It said actually we should just shut the whole thing down, which obviously is not happening. Dispossession, that's the consequence of the regime of the draft scheme rather than its justification or its purpose.
Sorry, just on, before we leave provision of ministry and mission, just to draw attention to 124, where the linkage is made between finance and governance and whether they can further the mission. So in other words, the provision of ministry and mission is being compromised, so it said, by problems with the finance and financial governance.
Absolutely, David. Absolutely.
Sorry, you were going on to dispossession.
Dispossession, that's the consequence of the measure. Obviously, it has to be taken into account, and it was, but it's not justification. It's just something which inevitably happens when a benefit is dissolved, as in this case. And then racism and sexism in paragraphs 135 to 139, and then over the page, Human Rights Act and Equality Act. Now, racism and sexism, those paragraphs address principally the most serious allegation that was raised at the oral hearing and have been raised in written representations. And those were allegations of direct racism. It's only natural in that context, and it's only proper in my submission that that should take the limelight because of the seriousness of the nature of that allegation. It's not the case that that means that the commissioners were totally unaware at the point which one sees running through all of the evidence, namely the allegation that the Reverend Yvonne Clark and the PCC together provided a special kind of ministry to UKME people. That obviously comes through all the representations. When I go to PSED very shortly, I'll take you through some of the paragraphs in that regard. But that's still factored into the decision making, but plainly it's a very significant thing if somebody says the scheme is motivated by racist purposes, and that was the core topic of those paragraphs.
Yes, well, that issue is not before us.
It's not before you, no.
I think we refused permission to appeal on that one.
You did, yes. My lord. But I think it's said by my learned friend, or has been said in writing at least, that these paragraphs are in error, or there's an omission at least, because we failed properly to address indirect discrimination in quite the same way. And that's the point which I was addressing there. And of course that doesn't run anyway for ground one, because proportionality is quintessentially a decision for this court, for the board. But I'll come back to that very shortly. But drawing all of those submissions together on differential impact and justification, you have my submissions that the church authorities simply don't accept that it is disadvantageous to UKME worshippers and residents in All Saints Spring Park to have the draft scheme come into effect and the parish dissolved, and to have the parish church as a chapel of ease and to have the pioneer minister. We just don't accept that is a disadvantage in a relevant sense. But were it to be plainly the extremely difficult financial and governance position of All Saints Spring Park for a long period of time now, with repeated interventions, repeated offers of assistance, is of a type in the present challenging mission environment, and when one thinks always what would further the mission of the church in Shirley, these are of a type that plainly sufficiently justify the draft scheme, plainly sufficiently justify it. It is really the only thing that can sensibly be done now, and that those are the views of the commissioners and of the various other church authorities that have considered this difficult issue over a considerable period of time. So those are my submissions on ground one. Ground two, PSED.
Just before we get there, I see that the commissioners addressed both the Human Rights Act and Equality Act. Were these submissions made to them that the HRA applied and the Equality Act applied?
I'll take instructions of those. No submissions were made to them that they applied, but I'm told that if I look at...
Actually, that's how paragraph 140 begins.
Oh, it says no submission was made. Yes. You're right.
Yes.
Shall I turn to PSCD, my lord, or other questions? No.
I've read Commissioners' reports before now, and I haven't seen reference to the Human Rights Act. And one of the reasons why this case was given permission to appeal was because of the assertion that the Human Rights Act applied.
I can see that's certainly an interesting point. So PSCD, whether it applies or not, is determined the same way as the Human Rights Act, so we needn't concern ourselves with that. In terms of compliance, if I just give your lordships reference to some of the recent Court of Appeal cases, you'll doubtless be aware of this, but over the past 2 or 3 years there have been various Court of Appeal cases saying don't treat bracking as if it were a statute. It's just a gloss on Section 149. One should always go back to the statute and consider the function in question and the way in which due regard should be given in the context of that function. I'll give you reference to 3 of those Court of Appeal cases that I don't have time to take you to, I'm afraid.
And sorry, and when you say its application is the same as the HRA, is that the core public authority and hybrid authority? Is that what you meant by that?
That is what I meant by that.
Yeah, so if you succeed in relation to the HRA on that point, the PSCD point doesn't arise.
Absolutely. So in Section 150 of the Equality Act, public function is defined as a function of a public nature for the purposes of the Human Rights Act 1998.
Okay.
I'm sorry, I'm not making my submissions in an orderly fashion at this point with time chasing me down, so sorry about that, my lord. First of all, Crown on the application of End Violence Against Women Coalition and the DPP. There's a case from 2021, and we have that in the bundle at page 2458. The relevant paragraphs are 85 to 88 in the judgment of the Lord Chief Justice, Lord Justice Burnett at the time. The next case is the Crown on the application of Sheikh and Lambeth, a 2022 Court of Appeal case. That's at page 2722. And in particular, paragraphs 56 and 57 at page 2739.
Just coughed it.
Sorry. Just for your lordship's note, in that paragraph, the Court of Appeals say that how intense regard will vary, perhaps widely, according to the circumstances. For example, the subject matter of the decision being made, the timing of the decision, its place in a sequence of decision-making to which it belongs. That's obviously relevant in our case. Period for which it will be in effect, nature and scale of consequences and so on. And they rely on the words of the Lord Chief Justice in End Violence Against Women. Also paragraphs 73 and 74. And the final Court of Appeal judgment on which we rely is Webb Harnden and Waltham Forest. That's 2023 decision. That's at page 3224. And again, same warning in relation to bracking, but that Court of Appeal refers to 2 different Court of Appeal judgments, so obviously they're all singing with one voice at the moment. In terms of the DMPC, we've already considered its functions set out in Section 3 of the measure, making better provision for the cure of souls when it considers it desirable, making recommendations to the bishop in relation to the pastoral scheme, when performing those functions, having regard to the various matters set out. In terms of sequence of decision-making, obviously only one stage amongst many, and of course Commissioner's job subsequently to go back and make sure that Section 6 was complied with. In the present case, it received written and oral representations, written ones from PCC and Reverend Yvonne Clark, and oral ones at a DMPC meeting on the 27th of February 2020, that's at page 298. If we look at the written representations at page 280, we see it said that the first point at A is All Saints in Spring Park as something to offer the local people which would be lost if it were to cease to be a parish in its own right.
And sorry, these are representations from who?
These are the ones actually which were relied on as for written representations purposes yesterday. So these are from the solicitors who represented the Reverend Yvonne Clark and the PCC.
Right. So this is Lee Day?
No, it's Lee Bolton, Monier Williams at the time.
Right, okay,
they
sorry.
Swapped representatives.
But anyway, they're solicitors for...
They're solicitors for the applicants.
Right.
Yeah. And then we see on that same page, 280, I'm not going to take your worship through all of this, but on 280, setting out this sort of impact on UKME people argument. So those representations were made to the DMPC, and then in the minutes of the DMPC meeting at 299, paragraph 62, a thorough discussion followed. So there's been a part of the meeting at which the PCC and the Reverend Yvonne Clark attended or asked questions. They left the meeting, then the meeting moved on to their decision-making phase. A thorough discussion followed, including considerations of ... the demography of the parish and statistics, and the nature of existing ministry, including respect of ethnicity. So I say that that is paying due regard in the circumstances to the impact of the measure on those of UKME origin. There's no express reference to section 149, but we know from the cases there doesn't need to be. You just need to be mindful of the substance of the consideration. Turning to the commissioners, I've addressed you at length now on the commissioners' functions, and you're well aware now of the commissioners' role in the process. I've taken you already today to the letter by which the commissioners summarised the written representations and put questions to the bishop. And you'll recall that one of the questions which I took your lordships to was, what do you think about this point relating to bespoke ministry which appeals to religious minority groups? So plainly the commissioners had that in mind. It was a question they posed to the bishop. That's at page 486. And the bishop came back and gave us his views. We then ultimately had the oral hearing and explained in the statement of Dr. Poole, that was at the request of the PCC in particular. She says that at page 82. And we have Dr. Poole, who chaired that hearing. We have the witness statement from her setting out what happened at the hearing. I take you to her statement, actually, page 82.
Pardon me.
At page 83, in paragraphs 38 to 45, she describes the way in which she ran the hearing. And then at paragraph 48, she turns to consider the committee's decision. And 48, in terms of the substance of the proposed scheme, we took on board and considered carefully what had been said about alleged racism and were moved by the submissions which had been made. We also considered the impact of the decision on the UKME population in the parish and the diocese more generally. However, notwithstanding the arguments made, as the JCPC, we agreed that the scheme should go ahead. And she sets out other parts of the decision-making process. And then in the full statement of reasons, which is in this...
Sorry, just a small technical point. And usually where you have a statement of reasons, you're not allowed to go to witness statements behind the reasons.
That's right, my lord. And I can rely solely on the statement of reasons. I'm not sure that she adds massively to what one sees on the face of the documents.
All right, so am I right in thinking you're not asking us to depart from that usual?
I'm not asking you to depart from that usual position. So if we go back to the full statement of reasons, on page 18, paragraphs 10 and 11, we see Masway from the day refer to the issues of racism, refer to the Amendment to Action report, to which your lordships were taken this morning, repeated reference to direct discrimination, institutional racism, but we also have in paragraph 11 a reference to the value of a black-led ministry and a black-led PCC. And paragraph 17 on page 19, inevitable black flight or loss of souls, black flight more significant than white flight, and so on. For black worshippers, there was special joy in going and worshipping where there was a black minister.
Which paragraph? I'm so sorry.
Paragraph 17. Sorry,
17.
I'm going too quick.
It's my fault.
There's page 19. So we see again submissions about the special nature, as it said, of the black ministry. Then in paragraph 98, this is Bishop Rosemary. Giving evidence about the pioneer ministry, how it might not be parish-based in exactly the same way and could focus more on UKME engagement. Paragraph 109, Bishop Rosemary talks about racism again. And then we turn to the Commissioner's decision, paragraph 129. We have been considering traditions, needs, characteristics, and so on. We have the part of the decision in relation to racism and sexism, focusing on direct racism, as I've said earlier, but again considering structural racism, and they may well be close to the benefits of the ministry, which is asserted by my learned friend. Then on page 140, express reference to the Equality Act. So subsection 5, keeping an open mind, the committee had careful regard to the PSED, to the extent that the duty would apply to the exercise of public functions, due regard to the requirements of that provision, but noted it didn't require a particular outcome. Little 6.
This has a slight hand of a lawyer, this page. I mean, it doesn't necessarily invalidate it, but...
It doesn't invalidate the core of the reasoning, my lord. And if I take you in particular to the end of this paragraph, little 6, where we have in brackets, the commissioners noted the clear view to which they come that the scheme would further the mission of the Church of England based on the material they received. Notice that it was limited in its effect. That's a reference, of course, to Chapel of Ease and so on. And that there was no evidence that individuals from any group. And then we have the language of the PSED, which, of course, we know, we're told the committee was shown that language. But when they say there was no evidence, plainly what they weren't saying was, oh, they suddenly dramatically forgotten all the various submissions and representations that have been made to them along those lines. That really means it's just a rejection, a substantive rejection of the arguments that have been made to them. And in my submission, that is a entirely legitimate, quintessentially legitimate satisfaction of the PSED. They listened to the representations, they had due regard to them, they took them into account, and they rejected the core disadvantage that was put forward. And that's why issue 4, underground 1, matters to me, another reason why it matters, because we don't agree there's a disadvantage for persons of the UKME background. And you have my submissions, my lord, in my written case in paragraphs 93 to 96 in relation to materiality. And I would obviously accept that the standard position for PSED is that a breach is always taken to be material, but there are also instances in which a declaration has been held to be sufficient relief, and there hasn't been a need to retake the decision if the outcome would be clear, nevertheless. And that happened in Webb Harnden, actually, one of the Court of Appeal cases to which I just referred your lordships. That's at page 3240. So very, very quickly then, ground 3. So my learned friend was in a sense candid in saying that he acknowledges he's got difficulty for grounds 1 and 2 because he has his threshold problem at public authority. But he says, well, I can get to exactly the same place under ground 3. And of course I say, well, you can't get to that same place under ground 3. So ground 3 relates to the classic exercise of this board's jurisdiction under the measure, which has been considered by numerous boards, and we have many authorities in the bundle. The core one perhaps is Hargreaves, and I'm not going to take you to because of the time, but 2059, in which Lord Keith, Lord Scarman and Lord Brightman consider this jurisdictional question, the full appeal question. It's a full merits appeal, but nevertheless we know that if there is room for 2 reasonable opinions, the fact that the church authorities have adopted one will almost always be decisive against the other. And we also know that the legal regime established by the measure sets out a series of considerations that we take into account, that the church authorities take into account when deciding whether or not to make a draft scheme. Critical 1, the mission of the church. Then we have in 3.1, worship and the mission of the church. In 3, we have cure of souls. In section 3, sub 2, we have financial position of the parishes and the diocese. We have the statute specifying the considerations which we have to take into account, and otherwise it's for the commissioners to determine the considerations which should be taken into account. Now, my learned friend, for strategic and advocacy purposes, and doubtless because this is what they would like the position to be, says that we are subject to a legal obligation to adhere to something which is the same as Article 14 or the PSED when exercising our powers under the measure. And we say that's just not the case. That doesn't translate into us wanting to do anything nefarious or bad or suboptimal. We are dedicated to diversity and to improving the position on diversity, but we are not subject to those obligations. So I'm afraid he's wrong on that. And if one thinks about the classic review function, appeal function of this board, plainly our view is a reasonable opinion. I've taken you through some of the underlying materials on the financial viability of the parish. I've taken you through the governance position. I've taken you through, albeit lightly, some of the very serious issues with mission, and you'll see that going through the documents, my lord, the very poor attendance that we have in the congregation. I've taken you through the way in which the other 2 parishes work, how viable they are, how secure, and the better footing that mission will be on in Shirley following the scheme. Plainly, this is a reasonable opinion for the commissioners to hold, and that means that ground 3, in my respectful submission, should be dismissed.
I mean, ground 3 is summed up in one sentence in paragraph 86 of the appellant's written case, which is the respondent has not had adequate regard to the unique mission of All Saints and to the indirectly discriminatory effect of the scheme on BAME congregants and residents. Now, let's leave indirectly discriminatory to one side and substitute detrimental, because that moves us away from technicalities of discrimination. That's the case you have to meet. You haven't paid sufficient regard, is how it's put there. Incidentally, in the petition of appeal, it was put slightly differently. It was put that a concern for the cure of souls necessarily requires a concern for the differing needs of different racial and ethnic groups within and outside the church, rather than a one-size-fits-all approach to ministry. The commissioners had no regard to this factor in reaching the decision. So I suppose what I'm not quite clear about is whether you say this is a factor that the commissioners should have had regard to and did, or that it's a factor that actually isn't legitimate in terms of the church's mission.
There's no legal requirement to have regard to that factor. It's dissonant in part with the church's mission, but we did have regard to all the representations made, which raised that point. So we didn't have to do it. It was partially inconsistent with mission, but we did in fact think about it. That's my answer.
Well, not every aspect of it was inconsistent with the mission of the church.
Not every aspect, no.
No,
my lord. I realise I've not replied on my learned friend's jurisdictional point, which he made this morning. I'm relatively happy that everything I said yesterday covered the ground which I need to in relation to notices and whether when one puts in the notice, the registrar was under a legal obligation then to conduct inquiries in relation to who represented whom in prior proceedings, such that even if she didn't, she should be legally deemed to have that knowledge and read the notice differently. But I say the registrar was under no such obligation. You read the notice by reference to the information that you have. Of course, information you're deemed to have, in the sense that if the notice has something written on it and you close your eyes and don't read it, you should be deemed to have read it. But I don't say, with respect, that my learned friend's submissions this morning change his case of yesterday, unless I can be of any further assistance.
Thank you very much.
Thank you.
Yes, Mr. Thomas.
Thank you, my Lord. My Lord, can I start with a question that Lord Sell, you asked me earlier on today about the Cayman Islands case, Royal Cayman Islands case, and the question that you specifically asked me was if it could be challenged, if it can come within the ambit of Article 8 for the reasons just articulated, and when say what the discrimination is, and the comparison between, in that case, it was a situation where, well, can I take paragraph 94, and I'll explain it in that way.
Could you just give us the page?
I think you're looking for it as we worked out.
Forgive me.
It's around about 3791, which is the paragraph you said you wanted?
94.
Yeah, that's 3043.
No.
3043. Thank you. So there it's stated it's necessary to consider the severity of the consequences for the individual police officers' private life, in particular as regards their inner circle, their opportunities to establish and develop relationships with others, and their reputations. The distinction between that case and this is here, Reverend Yvonne's opportunities to establish and develop relationships with others will be affected. She'll lose her incumbency, but also her home, which was the parsonage house. And another distinction is she will be separated from the parish community where she's ministered over many years. And if she finds another role in the Church of England, it's going to be unlikely that it's going to be in the same area, so she's going to be separated from the relationships that she's built up with other parishioners. But the scheme also affects her reputation, so there's more than a tenuous Article 8 link. The diocese and the commissioners have, in justifying the scheme, as we've just heard, been highly critical of the state of the parish under her care, including the state of the parish finances, its governance, its responses to requests from the diocese, and the level of attendance at services. These criticisms, while perhaps not intended to be personal, obviously affect her professional reputation and her ability to find another role within the Church of England.
I think the point that's taken against you, though, is that when one comes to the Article 14 discrimination aspect of the case, but you don't have a straight Article 8 objection to what's been done. It's said to be discrimination against a group of people, and Reverend Yvonne is able to present that claim because she represents that group of people. So it's not discrimination against her, it's discrimination against that group. Whereas you've been showing us reasons why she is affected, but not Article 14 reasons that she could rely upon. she personally could rely upon.
I accept that, and as I think was said earlier, Article 8 was a second string to the bow because I had Article 9 in any event.
Yes, that's fine.
Just on that point, in terms of her bringing it on behalf of the other, is the point I made yesterday, and I repeat it again. The only addition I would add is she is the ministry, and the ministry is her. So even though it may look like it's a right that's being exercised on behalf of others, she is part and parcel of that ministry, but that's as far as I can take it. Can I just make a couple of other points? My Lords, I want to take you to, just in terms of some of the criticisms that we've heard in relation to Reverend Clark, what we consider to be an important statement, and it's on page 74 of the bundle.
73, did you?
74.
74.
And it's the statement of Dr. Catherine Eve Poole, and she was the Third Church Estates Commissioner, and she chaired the committee. You'll see that at paragraph 1 on page 74. Do you see that? Mm-hmm. And the reason why I'm taking you to her statement, because I want to take you on to page 86, if you move on, and the conclusion, which is at paragraph 56. And there's a discussion in the middle of that paragraph about the decision to bring the incumbency to an end. And it's important to recognise that even the church commissioners say this. We were also acutely aware that the consequence of our decision would be to bring to an end the incumbency of Reverend Clark at the parish. And it's the next words, who had such a pioneering and inspiring role both in and beyond the parish. And the reason why I mention that, because I think it's important to Reverend Clark, and she would want me to bring it to your attention, that this isn't a case where, despite the financial criticisms in relation to the running of the parish that you've heard, that there was any suggestion of anything of a disciplinary nature against her. And I think that this board ought to acknowledge that.
Well, I don't think it's been suggested that there is anything of that nature.
No, but I think it's important that I underline that.
I understand why you make the point.
Thank you.
The whole thrust of the case against you is not a personal decision directed against her personally.
I understand that, and I've heard that, and I'm not. It won't make my submissions any better to repeat the very long submissions that I made in relation to particularly ground 1 and how I coupled them with ground 3 earlier, and I rely on and repeat those submissions. So that is what I say in reply, my Lords.
Yes, thank you very much, Mr. Thomas. Well, the board will wish to thank council who have appeared yesterday and today. We'd also like to thank those who sit behind council and have assisted them in the preparation and presentation of their cases. Perhaps unusually for this court, whether sitting as the Privy Council or as the UK Supreme Court, we have had a constant representation in court of members of the public. You have sat politely and courteously and listened to the arguments, legal arguments of the last 2 days. Now, the board recognises that schemes of this sort can engender strong feelings and also proposals to amalgamate parishes or closed churches can often cause heartache for those who have worked to maintain the church's mission in their community. So the board thanks you for your courteous and patient attendance. The board will have to consider all of the submissions made in this case with great care, and will take time to consider what advice they will humbly tender to His Majesty. The board will now adjourn.